Tell me this isn't just frustrating, tragic, and confusing. After being savagely injured by his own father when he was just a few weeks old, a little boy is ordered to be returned to him, taken from a loving foster family, only for the boy to eventually die by his father's hand. We're diving into the death of 4-year-old Zaydian Dopirak and the legal consequences surrounding his story. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. That's right, Morgan & Morgan is investigating claims that patients weren't properly warned about this risk. It's free to check, just takes a few minutes, and you don't pay unless they win. So scan the QR code on screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. I need you to hear the progression of this story, okay? Back in 2018, out in Missouri, when Zaydian Dopirak was just 5 weeks old, he was critically injured, taken to the hospital due to alleged physical abuse from his father, Blake Dopirak. More specifically, he apparently crushed his newborn skull with his bare hands, okay? So little Zaydian is taken from his father and was sent to live with foster parents, Dawn and Jeff James. According to CBS 4, this is when Zaydian was just 4 months old. And because of his injuries, this foster family was told this little boy would never be able to walk. But turns out he did. He made an amazing recovery, according to them. Per reporting from Fox 2 Now, Dawn said, quote, he was excelling in everything they said he would never do. So what did the Jameses do? They petitioned for full guardianship and to make sure that this little boy didn't return back to his biological father. According to KTVI, social workers, a guardian ad litem, this is a person appointed by a court to represent the best interest of a child during legal proceedings, a pediatrician, they all told the court that it was a danger for Zaydian to be with his father. But despite all of that, the state didn't agree. According to Fox 2 Now, Dawn said, when you have so many people telling you that if this child is returned home, he will be killed, you need to listen to that. We were shocked when the judge said she was going to do a trial reunification. That's what happened. Zaydian was returned to his father. And what happens? He kills him. Kills Zaydian when he was 4 years old. According to Law&Crime's own reporting in KSDK, on January 2nd, 2022, at around 8 a.m., emergency medical personnel and officers with the St. Louis Police Department responded to a 911 call from Dopirak, the father. His son had suddenly stopped breathing, so they show up to this home in Manchester, St. Louis. Zaydian was taken to the hospital where he died from what authorities concluded was, quote, abusive head trauma at the hands of his father, who confirmed he was the only one in the home when his son stopped responding. Dopirak was charged with the felony crime of abuse or neglect of a child resulting in death, but now Dopirak ended up pleaded guilty to 1 count of endangering the welfare of a child resulting in death, and he was sentenced to 24 years in prison. Now, the county prosecuting attorney, Melissa Price Smith, said, justice has been served. We are relieved for this family that this painful chapter is over and they can continue on their path to healing. May this angel rest in peace. So many questions. Let me bring on Missouri criminal defense attorney Allie Young to talk more about it. Allie, good to see you. Thanks for taking the time.
Good to see you, Jesse. Thank you for having me.
Your reaction to this case, as I laid it out, it's quite the progression to say the least.
No one can react properly to this. This is a tragedy. The courts failed this boy. The courts failed the foster family, who by all accounts did everything they possibly could do right for this boy. And it still ended in tragedy.
Why do you think he took a plea, and why do you think that was agreed upon by the prosecution?
I think that he took a plea because he admitted in a statement to police that he was the only one around. He was the only one with the boy when he passed or when he went unconscious. And at that point, your defenses really struggle. I mean, we don't get to see behind this third wall and see were there any expert witnesses involved as far as any other injuries that could have caused this, things like that. So I would assume that defenses were exhausted and the writing on the wall was there.
Was he going to be facing a stiffer sentence, what he was initially charged with respect to what he actually pled guilty to?
No. So he was initially charged with abuse or neglect of a child, the Class A felony resulting in death, which is a range of punishment of 10 to 30 years or life in the Missouri Department of Corrections. And he ultimately pled to endangering the welfare of a child resulting in death, which is still a Class A felony in Missouri. So it's still same range of punishment. It's one of those things where you don't really know why somebody would agree to one plea over the other, why it needed to be amended. They're both what we would consider dangerous felonies in Missouri, and so he still has to do a significant portion of that time. But I imagine it's one of those things where he was willing to admit to one thing but not willing to admit to the other, and sometimes that saves people grief when they get to the Department of Corrections as far as amongst their peers, and the charging language is a little bit nicer in endangering the welfare of a child as opposed to abuse of a child.
And just to be clear, this doesn't necessarily show that there was a weakness in the prosecution's case or a strength in the defense's case, because I am curious what his defense would have looked like. Was it a case, they might have had him dead to rights at trial and there was nothing really to do?
Yeah, I don't see a difference as far as or a strength or a weakness in these charging documents as they're laid out. I don't see where the case would have gone to trial. There could have been questions as far as who had done it or what happened. In a case like this, your defenses are kind of limited to it wasn't me and that's not what caused his death. And so if both of those items or elements are checked off the list, then yeah, your defenses are very limited.
Do you feel that in the end, I always ask this when you're dealing with the death of children, in the end, is it beneficial that there's no trial? You don't have to have a jury go through this. You don't have to have witnesses testify. The family doesn't have to see what happened here. You think it's good for the community in a way?
It's good for the community in a way that somebody is taking responsibility in a way that a jury trial or a bench trial wouldn't allow for. You see a defendant take responsibility for the actions that he or she did. But in a case like this, unfortunately, obviously the victim is not here with us. And so there's not a lot of grief or a lot of stress that's going to be placed on a testifying witness that is a victim. So is it going to hurt the family more so, or the victim more so, put them through more stress to testify or to go to trial when the victim is deceased?
You think 24 years is the appropriate sentence?
If I remove myself from my job, I have to say no.
Right.
I have to say no because the justice system is put in place to protect our most vulnerable victims, and this is the most vulnerable victim that you can have. I don't see a reason personally why a maximum sentence would not be imposed in a case like this or sought. That's just a personal opinion if I remove myself from my profession. It's a great outcome for the defense attorney and for the defendant, in my opinion. But the reason why our justice system is what it is to protect the most innocent of victims. And if this most innocent victim didn't deserve the maximum penalty as justice, then I don't know who would.
By the way, if it went to trial, would the 2018 episode of him crushing his son's skull with his bare hands, would that have come into evidence?
It definitely could. It could come in as propensity evidence. It could come in to show that he has a pattern of doing these types of things. The way that a jury could view the evidence legally kind of is construed there. A jury is going to look at the evidence in any way that they want to, but legally they're going to be instructed, hey, you just look at this evidence to show that he had a propensity to do this. It doesn't necessarily mean he did do this, but he's done something similar to it in the past.
Why wasn't he charged with murder?
Well, with endangering the welfare, it's not what we would consider a dangerous felony in Missouri, which means he would have to do 85% of the total time that was given to him. And so with pleading to endangering the welfare of the child, the Class A felony resulting in a death, even though he received 24 years, he only does a percentage of that based off criminal history and prior commitments to the Department of Corrections. If he were to have pled to child abuse in the first degree, the Class A felony resulting in a death of a child, that is an 85% crime or a dangerous felony, as we say in Missouri. And so you'd have to do 85% of the 24 years before he was eligible for parole. So that's the incentive that he receives by pleading guilty to endangering the welfare as opposed to child abuse. It's a very favorable outcome for the defendant because he does a significantly less amount of time because he doesn't have any prior commitments to the Department of Corrections. So he would do probably somewhere around 45% of the 24 years that he received as opposed to a mandatory 85% minimum.
I want to ask you about something at sentencing, because at sentencing, Zaydian's foster family was there, the Jameses, and it was reported by outlets like Pix 11 that it was a very emotional scene, understandable. There was reporting from Pix 11 that a prosecutor's office therapy dog sat with them. Is that typical?
You know, it's actually not typical, but here in Jackson County, which is in Kansas City on the other side of the state, there are two service dogs in Jackson County. One belongs to a prosecutor. His name is Jax, and he does go to work with her every day, and he sits in with victims, and he'll sit in with child victims when they're giving statements. I don't see it used often, but I actually have seen it in Jackson County now a couple of times. And I think it's a great tool to make people feel more comfortable and to make people feel more less anxious.
By the way, per Pix 11, Dawn James said, I know that Zaydian can never be brought back, but my family got justice for him today. Knowing that he's going to go away, I have a little bit of peace. And I actually want to talk about the Jameses for a second, because I have to get into how on earth this little boy ended back up with his father. That's the big question here, because you have to imagine, wouldn't he still be alive? Outside the court, Dawn reportedly said, we should never have been here if the courts would have originally listened. Remember how we mentioned all of those people who apparently testified as to the danger of this little boy being returned to his father? Well, according to Fox, everyone was on the same page. If this child were to be returned, something would happen to this child again. And what's crazy is there was a reunification hearing set back in 2022 to see how it was going, and Zaydian died 2 days before. Dawn had said, I beg to be able to give this boy a life that he deserved. Why, when you had so many people? Was he just a number? Was he just a case number for you? And here's the thing, Commissioner Diane Monahan, who apparently oversaw Zaydian's case, retired soon after. According to Pix 11, Dawn said, when Commissioner Monahan stepped down and we knew that no family would be put through this again, that did restore our faith. Allie, why would a commissioner not heed the advice of others if this reporting is true? Is there such a goal for reunification that it trumps legitimate concerns?
You know, and you said it, the goal in family cases like this is reunification. But just like any goal, some goals can't be met. They can't be reached, and that's okay. There's a reason that those safeguards are put in place, like a guardian ad litem. That is a person trusted by the court, an attorney trusted by the court, appointed by the court, to do what is in the best interest of that child. And when you have a guardian ad litem who is testifying and is actively saying, no, do not return this child to his father, he needs to stay where he's safe in this foster family, and you disregard that, it's unforgiving. There's no excuse for that. The judge in any case does not know best, and that is why a guardian ad litem is appointed, because they are intimately aware of details that a judge will never be aware of. They interview parents, they interview the children, they go and they do active interactions with the family to see how people interact with each other. And then you have a guardian ad litem saying this is not an appropriate placement, is not safe for the child to be reunified with their father. It begs the question as to why she would not listen.
Can she be held liable? Can the state be held liable?
Now, judicial immunity extends pretty vastly in this case. It will protect the judge, it will protect the commissioner over her decisions as to what she does civilly. It will shield her from any civil liability. It will shield her and to protect those decisions from whether it's her or whether it's another judge in a similar situation. The doctrine of judicial immunity protects judges in their decisions as long as they're acting in good faith. She acted in a manner that is consistent with the goals of family court, and so I can't imagine that she would that the doctrine of judicial immunity would be broken at that point.
Do foster families need more legal rights?
That's hard. That's a hard question to answer, because the foster system is so overly burdened that it becomes one of those things where, by all means, this was a success story for the foster family. They loved this little boy, they grew him, and they fostered this intelligent little boy who was not supposed to be much more than just not able to walk, not able to do things that you would expect a little boy be able to do. That's not 100% common in the foster system. But when you have guardian ad litems and you have pediatricians stating that the foster family is the best place for this child to be, then yeah, they do deserve those rights. They deserve those rights of guardianship. They deserve the rights of parentship, because they're essentially the ones that are acting as the child's parent more so than the parent actually is.
This is a heartbreaking case. It is heartbreaking. It is tragic on so many different levels. And the idea that this could have been prevented in some way, that's the part that it's kind of hard to get past. Allie Young, thank you so much for taking the time. It was really great seeing you.
Thank you for having me.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.